How's it going, everybody, and welcome back to Lead Therapy, and thank you so very much for taking time for tuning in to my video. Just a quick reminder, after you guys have watched the video, please leave any comments about the story in the comments section down below. And if you enjoyed the video, or if I gave you some information you didn't know, please like, share, and subscribe, and hit those post notifications. Also, at the end of every one of my videos, I always post 2 thumbnails to recent videos that I've posted. And if you're looking for something else to watch, you can click on one of those videos and it'll take you straight to it. Now let's get on with today's video. Increasingly partisan ACLU launches an attack on Second Amendment rights. Oral arguments in the U.S. Supreme Court case, New York State Rifle and Pistol Association versus Bruin, are scheduled for November 3rd. The case challenges New York's carry licensing regime, which grants unfettered discretion to government officials to determine whether a law-abiding citizen is allowed to carry outside the home for self-defense. In District of Columbia versus Heller in 2008, the court found that the Second Amendment protects the individual right to possess and carry weapons in case of confrontation. The present case offers the court an opportunity to affirm this right by ensuring that all law-abiding New Yorkers may carry outside the home. This case has garnered significant attention, and with it, a host of Amicus Briefs, which are also called Friend of the Court Briefs, from a wide variety of interest groups. This includes a bizarre brief, the American Civil Liberties Union. In it, the purported critics of government power defend New York's law, arguing that the government should be empowered to extinguish a central component of a law-abiding citizen's constitutional right to bear arms. To justify their involvement in the case, the ACLU concocted a tortured theory that posits severe restrictions on the Second Amendment right are necessary for the full enjoyment of our First Amendment rights. This is a case about the Second Amendment, but its resolution also implicates fundamental First Amendment values. The freedoms of assembly, association, and speech. States have many justifications for regulating the public carrying of weapons, concealed or otherwise. But one especially important justification is that such restrictions facilitate civic engagement by promoting safety and reducing the chances that the disagreements inevitable in a robust democracy do not lead to a lethal violence. Note that the NYSRPA case does not concern a government's ability to restrict the carrying of firearms in certain sensitive places. The Heller decision noted that nothing in that opinion should be taken to cast doubt on laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, where the type of civic engagement the ACLU is supposedly concerned about might take place. Rather, the present case concerns New York's ability to eliminate law-abiding persons' ability to carry outside the home entirely. Aside from the Second Amendment issues, the ACLU's position runs counter to much of the group's work. The notion of law enforcement officials doling out benefits to preferred individuals is an entirely discretionary manner should raise objections from civil liberties supporters. A coalition defense attorney groups, including Black Attorneys of Legal Aid, the Bronx Defenders, the Brooklyn Defender Services, submitted a brief in support of. NYSRPA explained, New York enacted its firearm licensing requirements to criminalize gun ownership by racial and ethnic minorities. That remains the effect of its enforcement by police and prosecutors today. The ACLU's brief is disappointing for an organization that has come to the defense of gun owners when the Second Amendment rights intersects with other important civil liberties. The brief is also concerning as it is symptomatic of a recent shift at the ACLU to put politics over principle. Pulitzer Prize-winning journalist and stalwart civil libertarian Glenn Greenwald summarized ACLU's recent abandonment of principle in a September 28 tweet, noting, "The real problem with the ACLU is the same plaguing so many other institutions in media and politics. When Trump became the center of universe for liberals, drowned in money by converting from a civil liberties organization to a DNC #resistance arm, and it's still addicted to that cash." The view is backed by ACLU's own admissions. A 2018 New Yorker item explained how the group has reinvented itself in the Trump era. This includes an increased emphasis on electoral politics. Therefore, it's understandable that some might get the impression, because the National Democratic machine is opposed to Second Amendment rights, the ACLU felt compelled to come up with some convoluted way to do its bidding. The ACLU's strained insistence that the Second Amendment must be ignored to preserve First Amendment rights is even more puzzling given the organization's softening stance on free speech. In a June 6 New York Times article titled "Once a Bastion of Free Speech, the ACLU Faces an Identity Crisis," reported on divisions inside the organization over its role as an advocate for First Amendment rights. Its national and state staff members debate, often hotly, whether defense of speech conflicts with advocacy of a growing number of progressive causes, including voting rights, reparation and transgender rights, and defunding the police. The piece quoted First Amendment litigator and former Ohio ACLU board member David Gallagher as stating, "I guess it was more important that the ACLU staff to identify with clients and progressive causes than to stand on principle. Liberals are leaving the First Amendment behind." Former ACL director Ira Glasser told the paper, "There is only one ACLU that is a content-neutral defender of free speech. I fear we are in danger of losing that." The paper also pointed out, one hears markedly less from the ACLU about free speech nowadays. Its annual reports from 2017 to 2019 highlight its role as a leader in the resistance against President Donald J. Trump. But the First Amendment or free speech cannot be found. So much of what should be the ACLU's core mission dovetails with robust exercise of Second Amendment rights. For instance, so-called red flag, gun confiscation order schemes, and attempts to deny gun purchases based on secret government watch lists denigrate the Fifth and Fourth Amendments, right to due process under law, warrant government spying and mass surveillance programs, infringe on the Fourth Amendment right, and impede the ability to exercise the Second Amendment right with adequate privacy. A legitimate understanding of First Amendment rights is necessary for gun owners to communicate and to politically organize to regress government in the face of increasing institutional opposition. And everyone's sincere hope is the ACLU will rediscover its commitment to constitutional rights. So there you have it. We can now add the ACLU to the growing list of people and groups that want to infringe on our Second Amendment rights. And as I said at the starting of the video, let me know your comments on the story in the comments section down below. And if you enjoyed the video, or if I gave you some information you didn't know, please like, share, and subscribe, and hit those post notifications. And I will see you guys in the next video.